Can a surviving spouse be disinherited? Have you ever wondered what happens to a spouse's inheritance when someone passes away? The question of whether a surviving spouse can be disinherited is a complex one. Let's break it down. Generally speaking, a surviving spouse cannot be completely disinherited without their consent or specific legal agreements. Even if someone tries to leave their spouse out of a will, many state laws protect the rights of the surviving spouse to claim a portion of the estate. Most states have laws that ensure a surviving spouse receives at least a minimum share of the deceased spouse's estate. This is often referred to as the elective share or statutory share. If a spouse is left out of a will or given less than this minimum share, they can file a legal claim to receive their rightful portion. This process is commonly known as taking against the will. In many states, the surviving spouse may claim between 1/3 and 1/2 of the estate, depending on local laws. This share can include a life estate in real property or a percentage of the estate's total value. In community property states, such as California, spouses automatically own half of the property acquired during the marriage. This means the surviving spouse can claim their half regardless of what the will states. Some states use an augmented estate approach, which calculates the elective share based on both probate and certain non-probate assets. This means that the surviving spouse's share could include more than just what is listed in the will. However, there are exceptions. A prenuptial or postnuptial agreement can allow a spouse to waive their inheritance rights. If such an agreement is properly executed, it can lead to disinheritance. In rare cases, certain misconduct by the surviving spouse, such as abandonment or felony conviction, may affect their rights, but these situations are limited and vary by jurisdiction. For anyone planning their estate, it is important to know that simply excluding a spouse from a will may not be effective. To legally disinherit a spouse, a valid prenuptial or postnuptial agreement or the spouse's explicit consent is usually necessary. Surviving spouses should also be aware of their right to file a claim to protect their inheritance. Estate planning professionals often advise clear communication with spouses and considering legal agreements to avoid misunderstandings. While it is theoretically possible to disinherit a spouse, state laws strongly protect their right to a share of the estate. Complete disinheritance without the spouse's agreement is generally not allowed, and the surviving spouse can assert their rights through probate court to claim an elective share. Understanding these rights can help ensure that both the wishes of the deceased and the legal protections for the surviving spouse are respected.